How does a second marriage affect stepchildren's inheritance? Have you ever wondered how a second marriage impacts the inheritance rights of stepchildren? This is a topic that can be quite complex, especially in blended families. In many cases, stepchildren do not automatically have legal rights to inherit from their stepparent. This is true unless they are specifically mentioned in estate planning documents or legally adopted by the stepparent. If a person passes away without a will or trust that names stepchildren as beneficiaries, those stepchildren typically have no claim to the stepparent's estate. This situation arises because intestacy laws prioritize the surviving spouse and biological children. So, if someone dies without a will, the estate usually goes to the spouse and biological children, leaving stepchildren without any inheritance rights. Now, consider what happens if the stepparent dies first in a second marriage. In this case, stepchildren may inherit indirectly through their biological parent, provided that parent is still alive. However, if the stepparent is the last to pass away, stepchildren usually inherit only if there are no surviving biological children or close relatives of the stepparent. This scenario is rare without clear estate planning in place. To ensure that stepchildren are protected in a second marriage, it is vital to take some specific actions. First, make sure to include stepchildren explicitly in wills, trusts, or beneficiary designations. This ensures they have a clear claim to the estate. Another option is to consider formally adopting stepchildren, which grants them the same inheritance rights as biological children. Additionally, prenuptial or postnuptial agreements can clarify inheritance expectations between spouses. These agreements can help avoid misunderstandings and disputes later on. Life insurance policies or separate trusts can also be set up to provide for stepchildren without affecting the surviving spouse's rights. Another factor to keep in mind is how assets are managed. When spouses combine their assets early in the marriage, it may be reasonable for both biological and stepchildren to share in the estate. However, if assets remain separate, it is more common for each spouse's estate to pass to their biological children unless stated otherwise. In a second marriage, a surviving spouse may also claim an elective share. This is a legal right to a portion of the deceased spouse's estate, which can override the will. This right can reduce the inheritance available to children from a prior marriage, including stepchildren if they are beneficiaries. Without careful estate planning, stepchildren in second marriages often face limited or no inheritance rights. Using legal tools such as wills, trusts, adoption, and agreements is essential to ensure that stepchildren receive the inheritances intended for them and to prevent disputes among family members.